Nothing we do is ever going to change, and throw my hands up and give up. That's what they want. Don't fall for that. Don't let your frustration, your anger and all that cloud you in that way. We keep fighting until there's no fight left. For the ones that are out there frustrated, we are this close to getting a decision.
In today's video, Attorney John Deaton discussed the latest with the SEC Ripple XRP lawsuit, the recent summary judgments from Ripple and the SEC, and what's next for the procedural process, likelihood of a settlement soon.
There are some judges out there that are what we call government hacks, right? That they just side with the government. They side with the government prosecutors. They side all the time. They side with the SEC. They side with the IRS. They side with the government. There are those that are so predispositioned that way that we call them government hacks. Judge Torres is not in that category. She has ruled against the SEC. She has ruled against the Department of Justice, and she's going to apply the law. Now, so what I realized is that this is your first introduction to so many of you to our civil justice system, a very imperfect system that goes by so I tell my clients all the time, the wheels of civil justice, they go, but they go ever so slowly. All right. And it is very frustrating, but to let your frustration start messing with your judgment is when you're letting it just get to you too much. It's frustrating. Chalk it up. The decision's coming. All right. When it's coming, we'll talk about. Another thing that I see out there is this secret plot. And let me just tell you now, if there was a secret plot, then why am I here? If there was a secret plot, why did 76,000 people get together? The motion to intervene that I filed had never been filed ever in the history of the United States. Let me say that again. A motion to intervene by a wife or a husband, when the SEC filed a case against them, they filed a motion to intervene. There was a couple of those cases, one out of Florida, where the wife said, hey, half of that property's mine. I should be a defendant in the case too. Aside from that scenario, never had individual investors come into court and said, hey, sue me too. Your case is so outrageous, SEC, you practically sued me anyways, and here's a putative class action at the time of 12,600 people that grew to 76,000. We want to be defendants too. Never been done. So for you people out there to say, oh, it's a plot and it's predetermined and this was written somewhere on a chalkboard in some secret meeting, then how do you explain us? Because you can't, because it's real. I've been in the courtroom. It's real. That $200 million that Ripple's spending is real. Okay. Just like when iTrust froze your XRP, that was real. Just like the fact that Coinbase delisted XRP and Kraken, that was real, and everything else is real. So you can believe what you want. You can put the 10 hats on, but it's nonsense. Okay. And when you take that attitude of, hey, it's already been predetermined, all you're doing is letting the bad guys win. Okay. As I tell my 4-year-old daughter when she says, what are you doing, Daddy? I go, I'm fighting the bad guys. Okay. You let the bad guys win. You let the Hinmans win. You let the Claytons win. You let the Gary Genslers win, right? Because they're just going to do their thing, and nothing we do is ever going to change, and throw my hands up and give up. That's what they want. Don't fall for that. Don't let your frustration, your anger and all that cloud you in that way. We keep fighting until there's no fight left to fight. Ripple's fighting. Brad Garlinghouse chose to fight. Chris Larson chose to fight. XRP holders chose to fight. Dragon Chain chose to fight. 16 Amikis chose to fight. Jeremy Kaufman chose to fight. Library chose to fight. Naomi Brockwell chose to fight. All right, now Coinbase is in the fight. Grayscale chose to fight. We just fight until there's no fight to fight, until we win. That's what we do. Okay. Let's see. Couple final thoughts. the timing that we're looking at. I've been telling people, like I did today, that is it possible that it goes past September? Of course it's possible. Anything's possible. But the bottom line is, you could look at history. Just like there is that one case I said back when, that it was 6 months after the Daubert decision. Well, that would put us to September 6th. All right. So until she passes September 6th, she didn't do anything that she hasn't done before. And so that's why I said worst case scenario, you're looking at late September, because on September 31st, she would have to report this case. This summary judgment motions have been pending for longer than 6 months. Her name would go on a list. It would go to Congress, and she's never been on that list. I assume she wants to stay off that list, and therefore we will see a decision from today until September 30th. And so for the ones that are out there frustrated, we are this close to getting a decision. We don't know exactly what that decision is going to be, but we're that close. Now, another thing I want to dispel for people out there are so many comments that say, if this judge wasn't on the take, she would have dismissed this case because of all of the corruption and the conflicts of interest and appearances of impropriety. Let me make it clear to you guys right now. There is no motion pending before this judge asking her to dismiss this case for any type of argument like that. Understand, she's a judge. She rules on things that are filed. No one anticipated some crazy guy from Twitter was going to file a motion to intervene after filing a writ of mandamus, arguing that 12,600 and more XRP holders want to be defendants. No one saw that. She reacted. She responded to it. She made us amicus. That's what she does, right? Brad Garlinghouse and Chris Larson filed a motion to dismiss. She ruled on it. The SEC filed a motion to dismiss the fair notice defense. She ruled on it. And no one, Ripple, Brad Garlinghouse, Chris Larson, no one has filed a motion that says, Judge, this case is based on corruption, throw it out. Hasn't happened. So for those out there that keep saying that, then you just misunderstand the way it is. No judge. If I were the judge assigned to this case, and no one has been more critical about the inside shit than me. No one has been after Hinman more than me. And I'm telling you, if I was the judge assigned to this case, I wouldn't just say, oh, you know what, I'm going to throw this case out because someone may have violated the financial conflict laws of the United States. I'm going to throw this case out because Ethereum got a free pass. It's not the way it works. If the judge thought that Bill Hinman violated the law, maybe that's why she said these emails go to impeachment of his credibility, right? If she thought something was bad, maybe she reports it, but she doesn't say, oh, Ripple gets a free pass because ETH got a free pass. It doesn't work that way. She doesn't say, I'm going to throw the case out because somebody let a group of investors talk them into giving ETH a pass. It does not work like that. I told you guys from the beginning, selective enforcement is not an argument that allows another case. The issue before is, did Ripple sell XRP that violated Section 5 of the Securities Act? All right. This is what she's ruling on, just so everybody understands. She has summary judgment by Brad Garlinghouse and Chris Larson that I believe she's going to grant, because I don't believe that there is a reasonable jury that would conclude that Brad Garlinghouse and Chris Larson were so reckless to not know that XRP was a security in 2013 and 15 and 17 when the SEC wrote a memo and couldn't conclude it was in 2018. All right. So I think that decision is an easy one. Then she has two other summary judgments to rule on: the SEC summary judgment and Ripple summary judgment. And that's it. Nothing more, nothing less. And if no matter what she thinks about the alleged corruption or conflicts, whatever you want to describe it, doesn't matter. She's going to focus on those particular filings. The SEC summary judgment is going to be based on what she's seen. Did Ripple offer XRP as an investment contract? She's going to look at, did the money that they offered Coinbase, is that enough? Did the money they offered Kraken, is that enough? Did they're putting on their website where you can buy XRP, is that enough? Were the brochure that they sent to 100 investors in 2014, is that enough? That's all she's going to do. She's going to look at that, and then she's going to make a decision. I know she's going to reject the SEC's all-inclusive XRP, no matter who sells it, under no matter what circumstances. She's going to rule against that, but that's her decision. Then she's going to look at Ripple's decision, and she's going to say, okay, do I agree with them that you have to have an underlying contract before you apply the Howey test, right? Do I agree with that argument? And I think she's going to reject that argument. Lewis today was much more, I think diplomatic about it, but I went on record. I think she's going to say a contract, transaction, or scheme. Plain language. The Joyner case, as Lewis brought up today, was a decision a couple years before Howey that found an investment contract, and there wasn't necessarily a written underlying contract in that case. And so those are her decisions that we're going to get, and nothing else. And so that's it. I hope that I've at least convinced some of you that the timeline and all of this, as frustrating as it is not something that points to nefarious things or bad things. Hang in there. We're close to it.